362. Assembly Bill 362 revises provisions relating to educational personnel. Assemblywoman Tolles, welcome, and please proceed.
Thank you, Mr. Chair. Thank you, members of the committee. For the record, my name is Jill Tolles. I represent Assembly District 25, and for the 1 and 4 and for the 1 and 6, this is for you. The Center for Disease Control estimates that 1 in 4 girls and 1 in 6 boys will be sexually abused before the age of 18. 93% of abuse survivors knew their abusers. Oftentimes, a close family member or friend or a trusted adult, like a teacher, a coach, or a mentor. 90% of the time, children do not report. In the first quarter of 2017, already there have been 10 cases in Clark County School District alone of educators sexually abusing or exploiting a student. 1 week before the session started, I sat in a county courthouse with a good friend holding her hand while her daughter testified against her music teacher. When the arrest hit the news, dozens of other reports came forward on social media or calls to the department spanning the last 20 years. AB 362 seeks to close certain reporting and communication loopholes between schools and districts so a teacher, administrator, or other school personnel cannot move from one school to another to sexually exploit or abuse children. This bill also seeks to define information sharing responsibilities and align with current federal policies found in the Every Student Succeeds Act. It would apply to all teachers, administrators, substitutes, and personnel who interact with children in public schools, including charter schools. With your permission, Mr. Chair, I'd like to go through the bill section by section. I'd also like to introduce Terry Miller, who is with Sesame, that's Stop Educator Sexual Abuse, Misconduct, and Exploitation. She is joining us from Las Vegas. We also should have on the phone Dr. Chester Kent, who has extensive experience in testifying as an expert witness, studying this issue, as well as was the original contributing author, along with Terry Miller, on the Pass the Trash legislation that was first adopted in Pennsylvania and is being adopted in states across the nation. Mr. Eglett would also like, from the Nevada Justice Association, has a friendly amendment that I would invite to share at the end of the presentation. I'd also like to make note that the Nevada Department of Education, as well as the school districts, have some suggestions for an amendment, and I am friendly towards those. We just have not had the time to work out the details, but I welcome their input. So with your permission, Mr. Chair, I'd like to move forward the section by section of the bill.
That sounds good. Please proceed.
Thank you. So as I said, sections 1 through 5 provide initial definitions and introductory provisions. It defines local educational agency, sexual misconduct, and sexual offense according to NRS 179D.097. Sections 6 through 7, addressed in Chapter 391, make changes to conform with the federal Every Student Succeeds Act. It requires that local education agencies and their employees, contractors, and agents may not help someone who works at a school to obtain new employment if they know or have probable cause to believe that the individual has engaged in sexual misconduct with a minor or a student. Exceptions are made for the routine transmission of administrative and personnel files and for situations in which the individual has been exonerated of the alleged misconduct. Law enforcement has investigated and found insufficient information or closed the matter, or the case of investigation remains open with no charges filed within 4 years after the reporting date. There were some concerns initially that this would be too cumbersome This makes those exceptions. There are also concerns about if the teacher was found to be innocent. This also addresses those concerns. It additionally bans local educational agencies and public schools from entering into agreements to keep sex offense convictions confidential. In Section 8, Section 8 requires job applicants for school districts, charter schools, or university schools for profoundly gifted students to submit information as to whether they have, number one, been the subject of an investigation concerning sexual misconduct unless the allegations were proved false. Number two, been disciplined or separated from employment while allegations were pending or found true. Or number three, had a license suspended or revoked while allegations were pending or found true. Also requires applicants to identify current and past employers and to authorize those employers to release similar information regarding investigations in regards to sexual misconduct. Sections 9 and 10 distinguish the responsibilities for the school or independent contractor and for current and past employers. Upon receipt of the applicant's information described above, Section 9 and 10 require the governing body of a school or independent contractor to contact the applicant's current and past employers for provision of employment dates and information, standard practice, regarding investigations of sexual misconduct. It also requires current and past employers of the applicant to comply with requests for such information, creating that two-way communication, and provides them with the immunity from civil and criminal liability for sharing that information. That's addressed another concern that was brought up in regards to this bill. Also requires the governing body or independent contractor to ensure appropriate licensure and to verify that the Department of Education has not received notice that the applicant is a defendant in a criminal case. Moving on to Section 11. It authorizes governing bodies and independent contractors to, number one, use the information collected through Sections 8 through 10 in determining whether to employ a person. And number two, to report such information to licensing, law enforcement, and child welfare agencies. Section 12 moves on to require independent contractors who employ a person who may have direct contact with students to maintain records about information collected under Sections 8 and 9 and to provide that information to the governing body of a school upon request and before assigning an employee to work at a location where the employee may have direct contact with students. Section 13 goes on to authorize governing bodies to allow temporary employment in certain situations pending the review of information. Section 14 permits governing bodies and independent contractors to conduct further investigations of a prospective employee and to require more information than is required of Sections 8 through 10. It permits a person to disclose more information than required in Sections 8 through 10 if there were concerns present. Section 15 prohibits governing bodies and independent contractors from entering into agreements that would, number one, limit the information sharing required in Sections 8 through 10. Number two, affect the ability of the governing body or contractor to report suspected abuse or sexual misconduct to the appropriate authorities. Or number three, require the governing body or contractor to expunge information about allegations or finding of suspected abuse or sexual misconduct unless the allegations were proven false. Section 16 requires that information collected through Sections 8 through 10 remain confidential and is not considered public record. Sections 17 and 19 provide penalties for willfully violating Sections 2 through 17 and makes provisions for tracking and refusing to contract with independent contractors who are violators of Sections 2 through 17. Section 18 requires that a notice of the denial of a license application must be provided to the school district or charter school that employs the applicant if the applicant is so employed. And then Sections 20 through 22 make various conforming changes to keep it consistent. And Section 23 specifies that the provisions of Section 15 do not apply to any agreement entered into before July 1st, 2017, until the agreement is extended or renewed. So with that, I'd like to pass it over to Terry Miller in Las Vegas, who has her prepared testimony, and then to invite Dr. Kent to join as well.
Good morning, Mr. Chairman. Good morning, committee members. Good morning, Assemblywoman Tolles. Before I get started, we've had a little bit of trouble getting Mr. Kent connected with the committee, so I believe your assistant is going to be helping him momentarily. All right. This has been a long time coming. In 1983, I learned of a teacher in my district that was caught in bed with a high school student. To ensure my children's safety, I began pursuing action against the teacher, and to my surprise, against a strong current of other forces, including school administrators, school district officials, law enforcement, and the community. After 11 years of struggle, in 1994, unsatisfied with the follow-up by school officials and law enforcement, I conducted my own investigation. What I found astonished and terrified me. I identified 60 victims willing to come forward to speak to authorities. It was then that I realized we were not dealing with an isolated predator. We were dealing with a deeply flawed system that protects pedophiles rather than children. In 1995, another case came to light wherein the teacher groomed a 17-year-old student and engaged her in sexual conduct. That teacher was not prosecuted, benefiting from the consent defense afforded him by law at that time. His resignation was swiftly approved by the school board, and fear set in that he would find his way into another school elsewhere. I led a parental effort to ensure that teacher would not be passed from that district as others had, resulting in his voluntary surrender of his teaching certificate. Both cases were the impetus for my lobbying efforts to criminalize educator sexual conduct with students in our state under SB 122 of 1997, and work to end passing the trash, which is now prohibited by federal law in the 2015 Every Student Succeeds Act, Section 8546, prohibition of aiding and abetting sexual abuse in schools. Several sexual predators disguised as educators have been passed in and out of Nevada. Two of the worst cases we have heard are those of Mark Zanna and Melvin Sprousen Jr. Case 1. In 1992, elementary school teacher Mark Zanna was accused of molesting 4 little girls in Pennsylvania. In 1998, his next victim, a second grader, would come forward in southern Nevada. Zanna managed to get both of those records sealed. With his teaching credential in hand, he found his way into 2 more Clark County, Nevada elementary schools, where he molested at least 6 more little girls. In 2007, 6 of his victims testified at his trial and finally stopped his reign of predation. Mark Zanna now resides in the Nevada State Prison for the rest of his life. Case number 2. In 2013, kindergarten teacher Melvin Sprousen Jr. was arrested and now convicted 10 days ago in Clark County District Court on kidnapping and child pornography charges. Sprousen encountered the 16-year-old girl who answered his Craigslist ad for a roommate. The girl, being a missing teen, was kept at his home for 2 months without her parents' knowledge or consent. It turns out, before Sprouson was hired by CCSD, he had a history of sexual abuse allegations during his employment with the Los Angeles Unified School District. As reported in the Las Vegas Sun, I quote, "He resigned as a fifth grade teacher in the Los Angeles Unified School District in January 2013. During his nearly decade-long tenure in California, Sprouson faced allegations of sexual abuse involving female students in 4th and 5th grade. Sprouson was investigated but never charged and did not lose his teaching license," unquote. Our state has had far too many cases of teachers betraying our trust by sexually abusing our children. In Clark County alone, CCSD records show 30 teachers since 2014 have been arrested for such offenses, 9 of them since January 1st of this year. That's 2 per week. Many of these predators could have and should have been stopped long ago when the first suspicions of abuse came to light. A government accountability report, K-12 education, selected cases of public and private schools that hired or retained individuals with history of sexual misconduct, found that one child molester can have as many as 73 victims in a lifetime. The accumulation of victims comes from passing those offenders, from school to school, district to district, and state to state. 1 in 10 K-12 students suffer some form of educator sexual misconduct in their school career, amounting to approximately 4.5 million children in the United States. And that comes from Educator Sexual Misconduct, a synthesis of existing literature, a report done for the U.S. Department of Education in 2004. It's the pool of mobile molesters in public, private, and parochial schools that proliferate such drastic numbers. AB362 is the adoption of the Sesame Bill, Act 168 of 2014 from Pennsylvania, the most comprehensive model together with the ESSA prohibitive language for states to adopt. What this bill does is address sexual misconduct with a proactive approach from the front end of misconduct. It mandates thorough vetting of school personnel, bans the use of confidentiality, collective bargaining, or separation agreements in instances of sexual misconduct or physical abuse, and it defines grooming behaviors as reportable disciplinary offenses. Our experts tell us that once grooming begins, physical sexual abuse will happen within 2 to 3 months. So if we address this problem early and get reports made early, we can prevent this from happening to children. Currently, there are 5 states that have this type of legislation. Washington passed their ban and prohibits those confidentiality agreements in 2004. Oregon followed in 2010. Missouri, with the Amy Hister Student Protection Act, was passed in 2011. Pennsylvania came on board with the Sesame Bill in 2014. And Connecticut is the very first state to fulfill the mandate under ESSA and adopt the Sesame Bill with HB 5400 in 2016. Nevada, New Jersey, and Massachusetts are the next in line to comply and adopt the Sesame Bill. We can stop child endangerment in schools right here, right now, with the passage of AB 362. We must stop passing the trash so children, parents, and teachers can be assured Our classrooms are predator-free zones. Again, I thank Assemblywoman Tolles for her leadership on AB 362. I thank you, Mr. Chairman, and the committee members for your attention to this vitally important bill. On behalf of Nevada's children, I ask for your protection by passing AB 362. I'll be happy to answer your questions.
Thank you for your testimony, Ms. Miller. Do we have Mr. Kent on the phone now? Mr. Kent, are you there? If so, could you unmute your phone and say something?
Yes, I'm here, and thank you very much for allowing me this opportunity to participate.
Please go ahead, Dr. Kent, if you wouldn't mind just stating your name and providing any testimony you wanted to give in support of Assembly Bill 362.
My name is Chester C. Kent, and I have a law degree and a PhD, and my biography, I believe, is summarized there on one of your sheets. Basically, my purpose is to assist Terry, and by way of explanation, I was the expert witness to Senator Williams, appointed by Senator Williams in Pennsylvania, who was responsible for developing and shepherding this bill through the legislature. That began in 2012, and by 2014, we had overcome all of the hurdles and formed a team of groups that included not only education associations, except the Pennsylvania State Education Association, which was neutral on the bill. They allowed the legislators to vote their conscience, but it included all of the other school-related organizations in Pennsylvania and the 67 county Pennsylvania District Attorneys Association. And over a 3-year period, we were able to overcome all opposition and pass the bill. And March of this 2017 will mark 2 years now that the bill has been effective. And it was a movement in the right direction in that the problem was, after my extensive experience in dealing with sexual abuse cases for the past 35 years, the chief problem is that school districts spent time training to prevent this problem, but the types of training and the types of laws that were on the books at the state level were not conducive to really addressing the problem from a legal, criminal, and even a school statutory point of view. By that I mean perpetrators were only caught after the fact, and they went on to victimize kids until they were stopped. The type of Sesame bill that was passed in Pennsylvania, much of which is included in this bill in Nevada right now, focuses on prevention from the perspective of stopping the perpetrator by recognizing the types of grooming practices called sexual misconduct, most of which are criminal in nature and should be investigated. And through that process of stopping this problem up front or making everybody in the school systems, especially the teachers and administrators, aware, that type of approach has much more promise. And the way you do that is to, as your bill states, in the bill now it defines sexual misconduct as a series of operational terms and operational statements, and virtually every case I've ever been involved with, most of those factors have occurred where teachers select students with a malevolent intent and seek to groom them by getting close to them and using their authority to build their trust and build a relationship where they eventually co-opt the student and prepare the student for sexual abuse. And that sexual abuse occurs in all kinds of situations where grooming is allowed to go on. Your bill, the Sesame bill, will help to provide a kind of a prehistory that is different from what exists now, a pre-employment history of any applicant that must be checked through thoroughly. And I guess I would call that, since that term is somewhat in vogue today, a form of comprehensive or extreme vetting to try to curb these teachers from entering your system. Now, I fully understand that approximately 1/2 of your new teachers coming in every year are coming from out of state. Now, we don't have numbers anywhere near that in Pennsylvania, and I hesitate to give you a number, but we are surrounded by states who produce teachers, a lot of teachers: Ohio, New York, New Jersey, Virginia, and Delaware, and they come into Philadelphia and Pittsburgh and along our borders into those towns. But by and large, the vetting system that could be placed as a result of this bill into practice is one whereby even if the people are from out of state and you lack the ability to coerce or to garner the cooperation of school districts outside of the state, it is important from the viewpoint of establishing a culture within Nevada in the schools, which has to change, whereby all of the teachers coming into the schools and the ones there start to embrace these kinds of ideas that this sexual impropriety with students and the safety of students is not allowed. And as a result of that, if you engage in such behavior, because of the cross-checks we have placed into the system, we have a good chance of stopping that type of behavior. And generally, just like how do you stop an embezzler, you provide as many cross-checks as possible. And in the Sesame Bill, one of the cross-checks is this extensive pre-vetting that goes on. And if there's any questions, and you're not getting cooperation, you don't necessarily have to hire the person, or you can hire the person provisionally and through a series of self-affidavits and so forth in the hiring process. If you're satisfied with the supervision of this person after a period of time, you might be able to hire that person permanently. But then again, if there are red clouds raised because of gaps in a person's experience or refusal to cooperate by prior districts in other states, that should be a red flag to you that, do you really want to hire this person? From there, what you're looking at is doing the type of teacher training which in the past has been highly ineffective. Now, I'm not saying to you that the training you now do in Nevada with teachers is ineffective, but I do have a son who went out to Nevada, Clark County 20 years ago, and he's a math teacher in the Clark County school system for the past 20 years, and I have 3 grandchildren in the system, and he's in a middle school. And his experience has been that the type of training that goes on is very bureaucratic in that teachers are given things to fill out and so forth, and the training doesn't make an impact on the teachers. And as part of this complex web that you have to weave of changing this culture is you have to start establishing a type of training program where principals take much more responsibility once they are trained for providing scenarios about how teachers began to groom kids and prepare them for sexual abuse. And through a process of having teachers respond to scenarios on a periodic basis during the school year in each school, you start to train the teachers to be more aware of the people around them. And I'm not saying that everyone is abusing. 99% of the teachers, probably 99.5%, are good, upstanding people who have the best interests of the students at heart. But there are always certain individuals that make their way into the school system because, as Willie Sutton, the famous bank robber, once said, where's the money? It's in the banks. That's why he robbed banks. Well, schools are full of kids. And if you have a predilection to sexually abuse kids, you go to schools and youth agencies and youth groups where students are and young people are present. So developing a process where the teachers become acclimated to how teachers with ill intent who seek to victimize students go about doing this, you create a scenario where sooner or later people in each school realize that they're not going to get away with this for very long. So as part of adopting a different non-bureaucratic process to train your teachers, you also should involve the parents at each school and your parent teacher organizations and get them involved and have a group or committee who gets trained and participates in this training and so forth, and start a process of applying this training through the parents and also through students in grades middle school and above. So I guess I would say after 2 years in Pennsylvania, we're now starting to see if this process that we've set into motion here via Sesame is effective. And I would say I see these cultures slowly changing after 2 years in the way that I see more and more reports coming from school districts where teachers are reporting and notifying that they're highly suspicious of a situation and it should be investigated further. And that process is going on. And it goes on through a state hotline, and the hotline informs the Child Protective Services in 67 counties within 24 hours to conduct an investigation. Or the local school administrators could notify the police. Now, I think your system, what's in your bill that I have noticed is better than Pennsylvania's because automatically it bypasses any bureaucracy and goes right to the police to determine if there's probable cause to initiate action. And, you know, police are the people who really should be investigating. So I think your bill is excellent in that regard. In Pennsylvania, administrators are asked to also notify the police if necessary. So to carry that one step further, this type of process, even if the police find that no criminal law has been violated, clearly moral turpitude may be an issue, and there may be many reasons why a teacher should be disciplined or dismissed or their license revoked or challenged because they shouldn't be around kids because of the type of behavior. And there are a number of reasons in Nevada in that bill, which already exist, which are also in the Pennsylvania law for disciplining a teacher. And I think sexual misconduct is a prime one, which you're attempting to add in to this. So even if a teacher is not convicted of a crime, it doesn't necessarily mean that he should be allowed to be around children, and the district could take disciplinary action. So I think that's the extent of my comments, unless you have individual questions, which I'd be happy to take.
Thank you for your testimony, Dr. Kent. We don't have questions at this time, but if you wouldn't mind staying on the line and maybe just muting, and when we open it up for questions, if we have one for you, we will let you know. We're going to come back up here to Carson City. Mr. Eglett, would you like to provide your testimony?
Good morning, Mr. Chairman and members of the committee, and thank you. And I would like to thank Assemblywoman Tullis and Assemblyman Watkins for sponsoring this very important bill. I would like to begin my comments by starting with a story that I came up and told my friend Senator Roberson at the very beginning of this session. In 2008, there was a music teacher by the name of Mr. Mazzo in Clark County at an elementary school in North Las Vegas. He was teaching music to 8, 9, and 10-year-old little kids. During that time, a number of children came forward through their parents with claims that Mr. Mazzo had sexually molested them. Criminal charges were brought, and there was a preliminary hearing. Because of difficulty with either the parents or the children getting testimony about this, the charges were ultimately dropped because the Justice Court judge determined that there was not sufficient evidence to be able to prove beyond a reasonable doubt that Mr. Mazzo committed these crimes. What then happened, during this period of time, the school district had opened up an investigation and was investigating Mr. Mazzo. When the criminal charges were dropped, the school district closed the investigation, scrubbed Mr. Mazzo's file, and transferred him to another elementary school in North Las Vegas, where he was then exposed to teaching other 8, 9, and 10-year-old children. Moreover, the school district did not tell the principal, the vice principal, or any of the teachers about these prior charges. He was given unfettered access to these kids with no supervision, and the investigation had been closed. So unsurprisingly, in 2015, better than a dozen children and their parents came forward with the same accusations at this school against Mr. Mazzo for sexually molesting 8, 9, and 10-year-old little kids. I should disclose that I am the attorney in Las Vegas who is representing the majority of those families in a case against the school district. What happened in discovery in that case is that we took a look at the teachers union's contract with the school district. And I'm not here today to bash on unions, and I hope that the clause that I'm about to read to you, the intended effects were not this, but it has had these intended effects from what we've seen in our discovery. It is from Article 12, Section 10 of the collective bargaining agreement. And it provides that in the event civil or criminal proceedings are brought against a teacher and the teacher is cleared of said charge, all written reports, comments, or reprimands concerning actions which the courts found not to have occurred shall be removed from the teacher's personal file. No reference to criminal charges as described above shall be included in the personal file. Entries into said file as they relate to civil or criminal proceedings described above shall be limited to violations of school district policy or administrative regulations which are known beyond a reasonable doubt to have occurred. Because of this clause in the collective bargaining agreement, the school district closed their investigation and nothing further happened, and this teacher was allowed to be transferred, or as you have heard, the trash passed to another school in our district. Beyond a reasonable doubt, I know there are several lawyers on the committee who practice criminal law. You know, beyond a reasonable doubt is the highest standard of proof there is. Almost all civil and administrative proceedings, the standard of proof is simply by a preponderance of the evidence. Even if you are bringing a claim for punitive damages in Nevada, the standard of proof is simply clear and convincing evidence, not beyond a reasonable doubt. So I told Senator Roberson this story in hopes that he would be willing to present a bill that would address this particular clause in the teachers union's contract with the school district. Because from our investigation so far, it is our belief that the exponential increase in sexual molestation cases in Clark County may be somewhat related to this very clause that was inserted a number of years ago into the collective bargaining agreement. We have seen an exponential rise in these type of cases in Clark County. And while I believe in unions, including teachers union, this clause is simply a bridge too far. I believe, as Senator Roberson promised me, that there would be other legislation that would address this and that we could add amendments to address this issue. And I believe this legislation offered by Assemblywoman Tolis and Assemblyman Watkins does that. For the 25 of the last 30 years of my practice, a small part of my practice has been handling these type of cases. But over the last few years, I have seen a disturbing trend that there is an increase in these cases exponentially in Clark County. I would tell you that just through the first week of April of this year, there has been 10 cases where teachers or staff have been charged with sexual misconduct with students. There were at least 10 cases in 2016 and at least 10 cases in 2015. I would like this part of my practice not to increase, but to be eliminated so these things don't occur any longer. And as a number of people have said, most of these cases go unreported. 90% or more of these students or their parents do not report these cases. So you can do the math as to how many cases there are likely going on in Clark County where this has occurred when you add those to the unreported cases to the reported cases. And in my experience handling these cases, and from the experts I've used, I know that this type of thing has a profound negative effect on children that are often immeasurable and take decades to realize. This causes these children to lose interest in school. It increases the dropout rate of these victims, and it denies them the education they're entitled to. Many of these people carry this burden for their entire life, and in adult life have complete psychological breakdowns as a result of this. It changes their entire education process and their opportunity to receive a good education. The number one goal of the school district and the teachers and their union is to provide a safe and secure environment to learn. Governor and this legislative body have taken, in my view, heroic steps over the past legislative session and this session to improve the quality of education in our state. But if a child is not or does not feel safe and secure while at school, the quality of the teachers or the school will not make a difference to that child. If the child doesn't feel safe or secure, he or she will not be able to learn while they're at school. So I urge this committee to pass this bill. I have proposed some friendly amendments that Assemblywoman Tolis asked me to discuss, and I believe they are on Nullis, and I provided a handout for you members of the committee today. One of the concerns I have in the bill is the phrase of knows or has probable cause to believe. The problem with the term probable cause, and there's a number of lawyers on your committee who practice criminal law, you know that probable cause has different definitions, and it can be argued over what is the standard of probable cause. I've asked that as a friendly amendment that be replaced with the term has either actual or constructive knowledge. Actual or constructive knowledge is very well defined in Nevada under our common law, and it means that the person actually knows, in this case, that this teacher has molested children in the past or is in possession of sufficient facts that a reasonable person would believe that this person likely has engaged in that type of activity in the past. And then in Section 7, we've asked for an amendment, and while this, in its current draft, this legislation goes a long way to preventing these type of clauses in a collective bargaining agreement to be enforceable when it comes to these issues, our proposed amendment to Section 7, I think, buttons that up even tighter, that where it provides that, or to keep the conviction or the circumstances surrounding the sexual offense or sexual misconduct by an employee, contractor, or agent involving the minors confidential. In other words, they cannot be kept confidential, which is what the current Article 12, Section 10 of the teachers' collective bargaining agreement with the school district does. And I'd be happy to answer any questions that this committee has. Thank you.
Thank you for your testimony, Mr. Eglett. We do have a couple of questions from committee members. We'll start with Assemblywoman Cohen.
Thank you, Chair, and thank you all for your presentations this morning. My question is regarding Section 8 and the use of the term employee. So we're going back and asking the other districts to give us information about teachers who were employees. But I'm wondering if by using the term employee, we're leaving out teachers who at the time were working on their practicums or internships or something like that. So there might have been a problem, but they weren't technically considered an employee. Does this cover them, or are we leaving those people out?
Thank you for the question, Assemblywoman. And it is my understanding that this does not apply to, for example, student teachers who are still in process, but in regards to those who might be taking a leave of absence to pursue a practicum, is that what I understand you saying? I might defer to legal to answer that question.
Go ahead.
Thank you. I don't believe those people would be covered by that, would be considered employees and covered under the provisions of the bill.
Okay, thank you. I guess my concern is because sometimes patterns start very early on in someone's career, and we have heard stories throughout the country of someone kind of shuffling from district to district. So it just might be important information to know that when someone started off their career as a student teacher doing a practicum, there were issues.
Thank you, Assemblywoman Cohen, and I'm certainly open to that feedback and perhaps clarifying the language if the committee so desires.
Assemblywoman Howdigi.
Thank you, Chairman, and thank you, Assemblywoman, for bringing this bill forward. Unfortunately, I heard this story as I was canvassing over the summer of a mother who shared her daughter's story with me, whose teacher had moved from a public school to a charter school and victimized her daughter. So I appreciate you bringing this bill forward. But my question is in regards to the same section, because I know we're talking about teachers, educators, employees of the school or school district, but does this apply to many schools have after-school programs immediately on their campus, like in their cafeteria, like the after-school All-Stars, ACEs, and those people wouldn't be categorized as teachers or educators? Would this cover them as well?
Thank you, Assemblywoman, for that excellent question. And yes, it does cover teachers, administrative personnel, bus drivers, as well as independent contractors, whether that's occupational therapists that might be coming in, or after-school programs, or some of the mentor programs that are coming alongside our social workers, for example. All those would be covered under this bill. Thank you.
Assemblyman Pickard.
Thank you, Mr. Chair. Just a quick question on the amendment to Section 7, where we're making sure that those records are not confidential. I certainly understand that from the perspective of the bill, and I'm supportive of the bill. I just want to make sure, because I don't know what the procedure is, that the names and identifying information of the minors are redacted, or at least that portion would be kept confidential.
Thank you, Robert Eglett, for the record, Mr. Chairman, and thank you, Assemblyman Pickard. Yes, it's my understanding that is always kept confidential. Even when we bring lawsuits for these cases, the names of the children are always kept confidential in the pleadings, so they're not disclosed, and I believe they would continue to be kept confidential through this bill.
Assemblywoman Krasner.
Thank you, Chair. Thank you for bringing this great bill. I would love to sign on as a co-sponsor if you'll have me. I did have just one question. Mr. Eglett, you mentioned that you have a current case regarding an issue that would be affected by this legislation. How will this bill affect your case? Thank you.
Thank you, Mr. Chairman, Robert Eglett, for the record, and thank you, Assemblyman Krasner, for the question. It is not going to have an effect on my current case. When we discovered the clause in the paragraph, we amended the complaint, included as a defendant the teachers union in this litigation. It's pending in federal court it's a Title IX action in federal court. It would not have any effect on the current case whatsoever, but what it would do, in my view, it would go a long way to prevent these type of cases occurring in the future, so that my practice in this area would hopefully be eliminated.
Any other questions from committee members? Hey, I don't see any. I want to thank you for your presentation. And before we get started, I guess if I could see by a show of hands, who would like to testify in support of this bill today? If you could raise your hand. That helps. Is there anyone who's going to testify in opposition to the bill? And then how about neutral on the bill? Anyone going to testify neutrally? Okay, I don't see anyone. So we'll take maybe someone in Vegas on the neutral side. We'll take testimony in support on Assembly Bill 362, and I would just encourage everyone to be as brief as possible. We've got about 20 or so minutes to get through the rest of this bill, so we'll start up here in Carson City. Whoever would like to start, please go ahead.
Thank you, Mr. Chairman. Members of the committee, Nicole Rourke representing the Clark County School District. We've been working with Assemblywoman Tolles on the bill for some technical reasons. We want to make sure that we can operationalize this bill to ensure the safety of children. We're definitely here in support. Wanted to let you know also in response to Dr. Kent's comments just regarding training, we have updated our child abuse policy very recently over the last 2 years. A lot of work went into that to ensure proper and immediate reporting on that. Also wanted to let you know that in addition to the training that we do with employees at the beginning of every year, that we do offer a course for parents that through our FACES, our Family and Community Engagement Services Department, we work in conjunction with the Rape Crisis Center to provide a course called It's Not Just Jenna, Abuse Prevention. And so to help train parents to identify, to assist children, and to help with that prevention. Again, we're here in support just to ensure the safety of children, and that is our primary goal. Thank you.
Thank you for your testimony.
Thank you, Mr. Chairman. Jennifer Noble on behalf of the Nevada District Attorneys Association. We'd like to thank Assemblywoman Tolles and Assemblyman Watkins for sponsoring this piece of legislation. That's a good effort to prevent sexual predators from gaining continued access to children by moving school to school. We're in support. Thank you.
Thank you. Mr. Dreer?
Thank you, Mr. Chairman, members of the committee. For the record, Ron Dreer, DREHUR, representing the Peace Officers Research Association of Nevada, our law enforcement coalition, and today I'm also testifying in support of this legislation on behalf of the Washoe School Principals Association. I do collective bargaining for them, and I can tell you in my past, I do a lot of collective bargaining. I've never seen proof beyond a reasonable doubt in a discipline discharge section or in that aspect. So was a little new to me to see that type of testimony or hear that type of something being in a collective bargaining agreement. Usually it's preponderance of evidence or clear and convincing. Very seldom do you have criminal. You usually have an administrative protections, which is what this bill does talk about. So on behalf of all of us, we do support AB 362. We do thank Assemblywoman Tolles and Assemblyman Watkins for bringing this forward, as well as the co-sponsors. Thank you very much.
Thank you, Mr. Dreer. Please go ahead.
Thank you. For the record, my name is Mary Brzezinski. I'm here representing Nevada Association of School Administrators, the Nevada Association of School Superintendents, and also the Nevada Association of School Boards. And protection of our children in our schools is obviously paramount. We appreciate this bill. There may be a few mechanical issues that we know we can work with the sponsor to work those out, but we very much appreciate her bringing this bill forward. Thank you.
Thank you.
Good morning, Mr. Chair and members of the committee. My name is Anna Sliding, and I am representing Hope for Nevada, honoring our public education. We represent nearly 1,000 families in support of public education in Southern Nevada. The stories that we have heard today are hard to hear. I am testifying in support of AB 362 for the following reasons. We believe that most educators are dedicated to the betterment and safety of the students that we work with. Most educators act ethically and do what is right naturally. We believe that AB 362 provides mechanisms to find those who don't before they are even hired. Ms. Miller mentioned teachers. However, that is not the only group of educators where incidences of molestations occur. We appreciate that 362 includes all employees, including substitutes. I am also a teacher at CCSD. We do receive trainings and recognize and report signs of abuse, including grooming. We are encouraged to do our part to act quickly to report misconduct. Last week, just another video plea was sent by the superintendent to all of us employees to be on the watch for suspicious behavior. We believe that this bill nicely complements AB 124 regarding a code of conduct for educators. We see AB 362 as the first gateway for potential employees to pass through the hiring process, and AB 124 as the pathway to keep current employees on track. With this combination, we hope to narrow the incidence of misconduct and hopefully eliminate them altogether. There are only a few bills at Hope that we jumping down for with joy. This is one of them. Our board supported it unanimously, so we at Hope are in favor of AB 362.
Thank you for your testimony.
Thank you, Chairman. Jared Busker with the Children's Advocacy Alliance for the record. We are in support of this legislation and wanted to thank Assemblywoman Tolles for bringing it forward. Thank you.
Thank you.
Thank you. Thank you, Mr. Chairman. For the record, Lindsay Anderson on behalf of the Washoe County School District. We are here in support. We have been working with Assemblywoman Tolles to clarify a few of our concerns, and I got this amendment today, so I think a lot of that is addressed in here, but primarily differentiating the roles of school district versus the department versus the role of the independent contractor, and so we appreciate her willing to work with us on that, and certainly in agreement that this is a serious problem that needs to be addressed. Thank you.
Thank you for your testimony.
Good morning, ladies and gentlemen. My name is Michael Gerlani. I'm the president of the Nevada State Law Enforcement Officers Nevada State Law Enforcement Officers Association. You can tell it's a Monday morning. And also part of the Nevada Law Enforcement Coalition. In the interest of time, I want to say ditto to the testimony of the sponsors and the supporters. We definitely support this bill. Thank you.
Thank you. Mr. McCann?
Morning, Mr. Chairman, members of the committee. My name is Rick McCann, Executive Director of the Nevada Association of Public Safety Officers, and also a proud member of the Nevada Statewide Law Enforcement Coalition. We appreciate Assemblywoman Tolles and Assemblyman Watkins and perhaps others that are joining as we speak to sponsor this bill. We support AB 362. Sexual offenses committed by those in the profession of education rank among the most despicable of conduct in our society. It is law enforcement who take those complaints and investigate these allegations. They meet the victims, they meet with the predators, and they know the details. Any loophole that permits sexual offenders and predators to move from one education position to another while their criminal and/or administrative proceedings are pending must be closed. AB 362 is a wonderful attempt to do just that, and accordingly we wholeheartedly support AB 362. Thank you.
Thank you, Mr. McCann. Ms. Mull?
For the record, Kimberly Mull, the Nevada Coalition to End Domestic and Sexual Violence. According to the U.S. Bureau of Statistics, on average, child molesters have more than 75 victims before they are caught. 75. Unfortunately, stories such as the United States gymnastics teams and Penn State are the norm. They are not the exception to the rule. The reason this continues to happen is because it is easier to believe that things are misunderstanding, or it's easier to push an individual along to become someone else's problem. Child sexual abuse is never a misunderstanding, and it is never someone else's problem. It's all of ours. It's a lifelong sentence for victims, and it has a ripple effect throughout all of our society. Because of this, we're asking you to not only support AB 362, but specifically in regard to the amendment that was talked about today on the records of confidentiality. On a personal note, let me be very specific with this. The most powerful and life-changing thing that you can ever say to a victim of sexual assault, and specifically to a child molestation, is "I believe you." Is the most powerful thing that anyone will ever say to any of us. Supporting this amendment and saying that even if a court does not find sufficient evidence to bring charges against someone, but that those records can stay in that file, allows the victim to know that the story that they had the strength to bring forward, if anything, at least it can possibly help protect the next child from being victimized, as sometimes that's the only thing that we have in this life. So because of that, we ask that you support both the bill and the amendment. Thank you so much.
Thank you for your testimony. Anyone else in support of Assembly Bill 362, either here in Carson City or in Las Vegas? I don't see anyone. Let's take opposition testimony. I don't believe there is any, but if someone would like to testify in opposition, please come forward to the table? I don't see any opposition. Let's take neutral testimony on Assembly Bill 362. Doesn't look like we have anyone here in Carson City on neutral, but we do have someone coming to the table in Las Vegas. Please proceed with your testimony.
Thank you, Chairman and members of the committee. My name is Dr. Amanda Habish-Deloy, and I work at the Nevada Institute for Children's Research and Policy at UNLV, and we house the state chapter of Prevent Child Abuse America. And I will make sure to be brief to be respectful of your time. We take several calls in our office that come in about help from all over the state for instances that are happening within our schools. So while we have a lot of examples from Clark County, I did want to mention that we also get calls from around the state from school employees even who get frustrated that when they feel like they try to come forward about reporting abuse, sometimes because especially in small communities, when you feel like you know people who may be claimed as the perpetrator, it can be hard to take those claims seriously because we don't want to believe that people we know can do such horrible things. And we just need to, along with passing, if this legislation is passed, you know, it's mentioned that we do need to work in Nevada to change our culture in the school systems to recognize that people don't always look like these monsters on the outside that we think that they might be to do these types of acts. So to make sure that we take all of these claims seriously and that people don't feel like they're threatened either to lose their jobs or to be dismissed by bringing forward these claims, I think that's really important to sustain this culture. And this is a problem that does happen statewide. I also wanted to mention that our organization, along with the Rape Crisis Center, we do have several trainings that are targeted towards children and families and individuals and organizations about training on how to recognize child abuse and neglect and how to prevent child sexual abuse and other types of abuse and neglect. And we are definitely willing to work with the school districts statewide to make sure that they have those resources to come in and bring trainings. Thank you very much.
Thank you for your testimony this morning. Anyone else in the neutral position on Assembly Bill 362? I don't see anyone. Assemblywoman Tolles would invite you back up to make any concluding remarks.
I want to thank you, Mr. Chair. Thank you so much, committee members, for hearing this important bill. I would also like to thank members of the Task Force for Child Sexual Abuse Prevention. We've been meeting since 2013, where we have been working on this issue, and Dr. Habush and many others have contributed to a comprehensive approach to helping keep kids safe, and this is just the next step. Last session in 2015, SB 394 passed to implement content standards in K through 12 education to help teach children that they have a right to be safe and who to go to if they need help. And out of that also were extended efforts upon the part of the school districts to teach the teachers, to teach personnel, to teach parents. And I want to thank them for all of that work over these past few years and applaud them on their efforts in regards to training children, parents, and staff and teachers. And what is exciting about this bill is that it takes it one step further to truly, truly protect and prevent from abusers getting into the system, getting into our schools, and having access to our kids. And so I'm incredibly proud of all of the efforts that were put into this legislation. I want to thank Terry Miller for her decades of work on this issue with Sesame, and for Dr. Kent for joining us today. I'd also like to thank, again, the Nevada Department of Education for their input, cooperation, helping form this bill, as well as the school districts and everyone who came forward in support. I'd also like to acknowledge and thank Assemblyman Watkins for co-sponsoring with me, and in addition, Senator Gansert and Senator Spearman, who have also signed on as co-sponsors. I'd like to address that there's been some other requests to add in to amend in to co-sponsor. Thank you, Assemblywoman Krasner, Assemblywoman Teresa Benitez-Thompson, Assemblyman Oscarson, and Assemblywoman Woodbury, and I would welcome anyone else to please step on board. Thank you. Thank you, Assemblyman Wheeler. We'll start an auction. Anyone else who'd like to step on board to co-sponsor this legislation, I welcome your support. Thank you so much for this important day in keeping kids safe.
Thank you. Ms. Miller, did you want to make brief concluding remarks as well?
Yes, thank you, Mr. Chairman. Terry Miller, for the record, President of Stop Educator, Sexual Abuse, Misconduct, and Exploitation, otherwise known as Sesame. I forgot to mention that when I started my testimony. I just want to address just a couple of things that came up in the testimonies and thank all of those who came in support and in all of the co-sponsors of the bill. With regard to those confidentiality agreements, in ESSA Section 9201, it is the sense of Congress that those confidentiality agreements should not be used in instances of sexual misconduct or physical abuse. So I just want to make that clear, and I think through that the federal mandate that we not conceal these crimes in any way, shape, or form, I believe that pretty much null and voids that clause that Mr. Eaglet brought to our attention. I'm very, very glad to know that that clause exists, and I believe through the federal law we can get rid of that. So thank you so much for everyone's testimony. Thank you for your time today, and let's do this.
Thank you, Ms. Miller, for your testimony and for your work on this issue. And thank you, Assemblywoman Tolles. I think the impressive coalition of supporters that you brought forth today shows that this is good policy. So please do provide any amendments that you may still be working on to staff when you have those. And again, thank you for your presentation this morning. We'll go ahead and formally close the hearing on Assembly Bill 362. Now would be the time for public comment. Would anyone like to give public comment either here in Carson City or down in Las Vegas? I don't see anyone coming to the table, so we will close public comment. Members, just so you know, we do have an 8 o'clock meeting tomorrow. We'll have a short work session, 4 or 5 bills, I believe, tomorrow morning, so we'll intend to take that up first, followed by 3 bills. Seeing nothing else, we will see you tomorrow morning. The meeting is adjourned.